All right, looks like we got everybody here. We will get started. Call this regular meeting of council, Town of Oliver, Monday, April 26th. Call a meeting to order. Are there any late items to add to the agenda? CAO.
Thank you, Your Worship. There are two. The Development Cost Charge Bylaw 1390 is coming back before council to rescind third reading and reread it a third time. And then the grant and aid request, South Okanagan Healthcare Auxiliary Society, is coming forward for consideration by council.
Thank you. Then I'll look for a motion that the agenda be adopted as amended by adding bylaws item I4, Development Cost Charge Bylaw 1390, and to business item J2, grant and aid request, South Okanagan Healthcare Auxiliary Society. Can I get a move?
So moved.
So moved. Thank you. Seconded. Call the question. Is anyone opposed to the motion? Motion is carried. From our closed meeting earlier this evening, I'll rise and report that council appointed Chantel Martin to the South Okanagan Aquatic Center Advisory Committee as the Town of Oliver member of the public. So congratulations, Chantel. I'll look forward to working with you on that advisory committee. On to the consent agenda. I'll ask if there's any items that anybody would like separated out from the consent agenda for discussion. Not hearing any. I'll look for a mover of the motion that the April 26, 2021 consent agenda be adopted.
So moved.
So moved.
Second.
Seconded. Thank you. Any discussion? Not hearing any, I'll call a question. Is anyone opposed? Motion is carried. Moving to committee reports. I'll ask for our chairperson, Councillor Rentamila, from the Committee of the Whole meeting earlier this evening to give us a report.
Thank you, Your Worship. At our meeting this afternoon, we had a busy agenda. It was a great meeting. We had a review of the first quarter update of our strategic plan, and everything seems to be on track. We reviewed the water regulation bylaw 1351. That will be brought forward to a future meeting for first, second, and third reading. We looked at building bylaw 1404. There were many points brought up and suggested revisions. So that'll go back to staff and come back to us at a future committee of the whole meeting for further conversation. And we discussed the grant and aid request, which will be on this evening's meeting from the South Okanagan Healthcare Auxiliary Society. There was lots of discussion around how money saved by the society will go right back into supporting our community. And so that will be coming forward this evening at tonight's meeting. And that's my report.
Thank you, Chairperson Ventimila. Moving to water matters, our first item is the 2020 financial statement. I will pass this over to the Chief Financial Officer.
Thank you, Your Worship. This is the for council to receive and approve the 2020 financial statements as presented. Over the past few months, KPMG LLP has been auditing the financial statements of the town. Canadian auditing standards require oversight approval prior to the finalization of the auditor's report and financial statements, and as such, council's approval is being requested. KPMG presented the audit findings report to council earlier this evening at a closed meeting, and there were no significant adjustments or control deficiencies identified during the 2020 audit. Thank you, Your Worship.
Thank you, Chief Financial Officer. Any questions for the CFO? Not seeing anyone. Can I get a mover that council receive and approve the 2020 financial statements as presented?
So moved.
So moved.
Second.
Seconded. Thank you. Any further discussion? Not hearing any. I'll call a question. Is anyone opposed to the motion? Motion is carried. Moving on to item 2, the 2020 statement of financial information. Again, I'll pass this over to our Chief Financial Officer.
Thank you, Your Worship. The Financial Information Act requires that all public entities submit specific financial information to the province and make it available to the public. The information is to be submitted in a prescribed format, includes annual audited financial statements, schedules disclosing remuneration and expenses paid to employees, and a schedule of payments made to acquire goods or services for the municipality. It is required that this information be approved by council at a regular open council meeting. The audited financial statements have been received, and the financial statements will also be forwarded to the ministry along with the attached statement of financial information documents. The Financial Information Act requires that all remuneration, benefits, and expenses paid to or on behalf of elected officials be disclosed, in addition to information regarding all employees where remuneration exceeds $75,000. As well, the town must disclose whether there are any severance agreements with non-unionized employees in 2020, which there were none. The Act also requires disclosure of suppliers who received aggregate payments exceeding $25,000, as well as others as an aggregate total. Total supplier payments were approximately $9.3 million in 2020. Thank you, Worship.
Thank you, CFO. Any questions for the Chief Financial Officer? Not seeing any. Then can I get someone to move the motion that council approves the statement of financial information for 2020?
So moved.
So moved.
Second.
Second, thank you. Any further discussion? I'll call the question. Is anyone opposed to the motion? Motion is carried. Anything to report this evening, Water Councillor Michelle?
Just the afternoon meetings, Your Worship.
Thank you. Anything to report this evening, Water Councillor Sadhu?
Nothing to report, Your Worship.
Thank you. Moving to bylaws. The first is the Sewer Parcel Tax Amendment Bylaw 1360.04. I'll pass this over to the Chief Financial Officer.
Thank you, Your Worship. In preparation of the 2021 property tax levy, the sewer parcel tax bylaw is required and must be adopted by council. The sewer parcel tax levy is included within the annual property tax notice for the town of Oliver. It is recommended that that council receive the Chief Financial Officer's report dated April 19, 2021 for information that council gives 3 readings and adopt sewer parcel tax amendment bylaw 1360.04. Thank you, Worship.
Thank you. Any questions for the Chief Financial Officer? Not seeing any. Can I get a mover of the motion?
So moved.
Second.
Moved and second. Any further discussion? Not hearing any. I will call the question. Is anyone opposed to the motion? Motion is carried. Moving on to item 2, Town Hall Heritage Designation Bylaw 1400 for adoption. Anything to add to this, Director of Development Services?
No, thank you, Worship. Town Hall Heritage Bylaw 1400 is before council for adoption, which designates the Town Hall building as a heritage site pursuant to Section 611 of the Local Government Act. Thank you.
Thank you. Can I get a mover of the motion that council adopt the Town Hall Heritage Designation Bylaw 1400?
So moved.
Second, please.
Second.
Second. Any further discussion or questions? Not hearing any. I'll call the question. Is anyone opposed to the motion? Motion is carried. Moving on to item 3, the 2021 tax rate bylaw 1405. I will pass this over to our Chief Financial Officer.
Thank you, Worship. The purpose of this report is to present council with the 2021 tax rates bylaw 1405 for first, second, third readings and adoption. For background, the operating and capital budgets general, which includes fire, water, and sewer, are integrated into the 5-year financial plan, which was adopted in late February, early March. The attached 2021 rates bylaw 1405 establishes municipal, general, and fire and regional district tax rates based on both organizations' approved 5-year financial plans. for 2021 year, the average Oliver resident is based on an assessed value of approximately $424,700 as compared to previous year 2020, which was $400,000. The 9% tax increase is expected to generate an average increase of $80 based upon that $424,000 assessed value. The average Oliver residents will also see the following changes on their tax notices. They'll see the regional district tax increase of $13, library tax increase of $2, hospital, the BC Assessment Authority, Municipal Finance Authority, tax increase of $5, school tax and police tax increase of $56. The total tax increase is estimated to be $156 compared to the previous year. As well, we have the taxes get assessed also on the different classes. Primarily the main other class that the town of Oliver has is the business class. And the multiple for the business class is 2.45. For the 2021 year, the average Oliver business is based on the assessed value of $360,700. And last year, it was $370,300. So you've seen a slight decrease in the business assessments in 2021. The average business assessed in 2021 will see its municipal tax payments increase by $62 when compared to the average business in 2020. As well as you're going to see the regional district portion decrease by $73, library decrease by $10, hospital, the assessment authority, municipal finance authority decreased by $9, and the school and police increased by $18. A total decrease of $12 for the business class as compared to the previous year. The following graph depicts a comparison of municipal taxes versus federal and provincial taxes for common household expenditures per day. When taken in totality, the municipal tax portion of household expenses is a very high value when considering the amount of services that are being provided. The services provided are roads, parks, fire protection, cemetery, planning and development services, building inspection, bylaw enforcement, airports, solid waste, and administration. So as you can see with the graph, and I've utilized this graph in my previous workplaces as well, the provincial and federal tax component based on a household income of $55,000, this is taken from the 2016 census in the town of Oliver, is approximately $33 a day. And when compared to the municipal portion, which is just around $2, and even if you add in the regional district portion, which adds in our recreation, now we're at about $3.50 when you compare it to $33. So I utilize this graph simply to show where you really should be complaining about high taxes. Because when you compare with your electricity, your house and car insurance, your TV, your phone, your internet, you can see what value you truly are getting from your municipal taxes per day. And I challenge anybody who feels that these numbers are incorrect to go back and to look at your own utility bills, look at your own property taxes, look at your own T4, and just do the simple math and divide it by 365. It's quite astounding when you look at it that way. And yet the local politicians take a lot of brunt that they are taxing us out of existence. When, like I said, I personally take exception to that. And I guess that's my soapbox, and I'll leave it at that. Thank you, Your Worship.
Thank you. Any questions for the Chief Financial Officer? Councillor Ventimiglia.
No questions, just a comment. I appreciate the CFO's soapbox speech. I love that graph, the household costs per day, as well as all of the other comparisons and breakdowns that have been provided. I think it really helps, as he mentioned, to put things in perspective and what we're getting for what we pay in different areas of government, but as well just in different areas of our lives. And yeah, I liked the soapbox speech, so thank you.
Councillor Mattis, did you have your hand up at one point?
I did, Your Worship. It was basically to echo what Councilor Ventimiglia said is appreciate the CFO having our backs.
Would you like to move the motion that the 2021 tax rate bylaw 1405 be read a first, second, and third time and be adopted?
I would be pleased to make that motion.
Thank you. Can I get a seconder?
I'll second that.
Any further discussion? Not hearing any. I'll call the question. Is anyone opposed to the motion? Motion is carried. Moving on to item 4, development cost charge bylaw 1390. I will pass this over to the Director of Development Services.
Thank you, Worship. The purpose of this report is to rescind third reading of Development Cost Charge Bylaw 1390 and reread a third time due to minor amendments based on feedback from the Inspector of Municipalities. The most recent DCC bylaw included charges that were carried over from the previous DCC bylaw for unserviced and serviced RV lots and campsite lots. As per the Inspector of Municipalities review, the province has indicated that an unserviced campsite or RV site cannot be charged municipal water or municipal sanitary system DCCs, as previously anticipated. It has been determined that only municipal roads and park DCCs are payable in this case. As such, the definition has been updated. The collection timeline for DCCs for campsites and RV parks have been further clarified in clause 4.3 at the request of the Ministry of Municipal Affairs. And with that, the staff recommendation is that council rescind third reading of DCC bylaw 1390 and reread a third time as amended, and that prior to adoption, DCC bylaw 1390 be referred to the Inspector of Municipalities for approval. Thank you, Worship.
Thank you, Director. Any questions for the Director of Development Services? Not seeing anyone. Can I get a mover of the motion? Oh, Councillor Ventimiglia.
I was just going to move the proposed motion that council rescind third reading of the development cost charge bylaw 1390 and reread a third time as amended, and that prior to adoption, development cost charge bylaw 1390 be referred to the Inspector of Municipalities for approval.
I'll second.
Second.
Seconded. Any further discussion? Not hearing any. I'll call the question. Is anyone opposed to the motion? Motion is carried. Moving on to business. Our first item, section 57 notice, 6228 Main Street. I'll pass this over to our building official.
Thank you, Your Worship. Good evening, Your Worship, and Mayor and Council, and member of the publics.
Baruch, are you able to share your screen?
Yeah. Is it on now?
Pick the one that you want us to see. We're seeing another one.
Fitness class.
The last one, sorry.
I think we should talk about this health and wellness break on Zoom next time we're like 8 hours in.
Sorry.
There you go.
Okay, good evening again. Section 57 notice on 6228 Main Street. The purpose of this report is to recommend that council pass a resolution under section 57 of the community charter to file a notice in the land title office for the property at 6228 Main Street due to unpermitted work that was completed without inspections in contravention of the BC Building Code and the town's building regulation bylaw 1140, and which has resulted in the building on the so I'm gonna reduce my screen. Building on the proposed being unsafe conditions. This is the map of the property location at 6228 Main Street. The background is September of 2020. the town became aware of the operation of the vacation rental without a business license within the second floor of the building. Through its investigation into this unpermitted and unlicensed use, the town became aware that 3 dwelling units currently exist on the second floor of the building. Neither the town of Oliver nor BC assessment have any records or building permits, which indicates that more than 1 dwelling unit should exist in the building. Through an on-site inspection, the town's building inspector has determined that the second floor dwelling units contain multiple contravention of the both the BC Building Code and Town's Regulation Bylaw 1140. As a result of this numerous contravention, the building inspector has determined that the building is unsafe. Due to the failure to call for inspection required under the building bylaw during the construction process, the dwelling unit may have additional latent deficiencies, which could not be identified during the non-destructive inspections. Section 57 of the community charter states, Section 57 of the community charter states that the building inspector may recommend to council that Section 57 be placed on the title of a property when the inspector during the course of carrying out the duties either A, observes a condition which results from a contravention of a multiple bylaw or provincial regulation, BC Building Code, that relates to the construction or safety of a building and results in the building being unsafe or unlikely usable for its expected purpose during its normal lifetime. Or B, discovers that something was done which required a permit or inspected under the bylaw and permit was not obtained. Although the community charter states that either A or B, in this case, both A and B apply as there are several safety and contravention to the town's building bylaw and BC Building Code, which results in the building being unsafe. Furthermore, no permits were issued for the construction of the suite or recent renovations. Section 8 of the building regulation bylaw 1140 states that every owner or agent shall comply with the building code and the building bylaw. Section 12 of the building regulation bylaw 1140 states that's unless exempted elsewhere in the bylaw, no person shall commence or continue any construction, alteration, expansion, repair, or placement of any buildings unless a building permit has been issued for the work by a building inspector. In this case, building permit was not applied for or issued for the work shown in the technical safety BC permits documents. The town has repeatedly notified the current property owner that a building permit application must be made to legalize the unpermitted suites and correct the existing contravention of the building bylaw and the building code, but the property owner has refused to comply. So here in the, we have the photos of recently completed work, new kitchens, new electrical work, new 240 plugs, new panels wiring, plumbing fixtures, heating equipment, and all the electrical outlets. This is the floor plan of the unit. So this is the main street here. This is the stair that going upstairs. This would be the front suite, like a living room, a bedroom, kitchen, and then there's another. There's a separate laundry part and a bedroom. So there's a 2-bedroom suite here at the front. This is a door that would be locked at night, and there's no exiting from any of this unit. Then the second, this is the mechanical room, which is all open. And then this is second suite here, kitchen, living room, bedroom, another bedroom. And then there's another door here. And then this is a third suite, and then it goes to the back door. So the code contravention, travel distance and exiting requirements. BC Building Code Consultant to confirm that the required exits, exiting, and egress from dwelling units meets the requirement of Section 3.4 of BC Building Code and Section 3.344. In particular, the separation of exits, access to exits, minimum number and location of exits required from the floor area, distance between the exits, the travel distance, the width and height of the exits based on the actual occupant load, the fire separation of the exits, exit sign, exit stair, the dimensions of landings, handrails, trades and riser, and clear width and ratings of the exterior corridor, exit corridor. Contravention, spatial separation and exposure protection of the building. So these windows are at the zero property line. So spatial separation and exposure protection of building does not meet the BC Building Code requirement of 323. So Part 3, Section 2, Subsection 3. So the limiting distance is the distance from the property line to exposing building face. Both sides of this building, they are at the zero property line. And these windows are added in the bedrooms on both sides of the outside wall. Technically, by the code, you are allowed 0% of actual unprotected openings into exposing building face when you have when they are at the zero property line. So at the current, the percentage of opening permitted by code is at 0%. It's not permitted. If they want to put any opening, they must be protected by like a wire glass, or the building must be sprinklered in order to have no window requirements. So the code consultant need to come up with the code report to provide, type of construction. Is it combustible construction or non-combustible construction? And meet the requirement of 323. Downstairs of this building, it's an assembly occupancy, which is A2, a restaurant, and has more than 110% occupant load, including staff. Upstairs is a residential occupancy, which is a group C occupancy with at least 3 suites. And the code consultant need to provide a report again that it meets all the floor safety requirements and all the fire separation of the floor assembly and all the required rating for the construction. So they also need to calculate the exit capacity and make sure it complies to 3.117 of the BC Building Code. Lighting and emergency power requirements. Their service facilities must meet the requirement of Section 3.6, in particular electrical wiring and equipment for electrical safety regulation. The fire separation around service room, attic, and roof space access. Minimum roof access, they need 550 by 900 mm. They also need to make sure they meet Section 3.7 of the health requirements and Part 7 of the BC Plumbing Code. Given that they have the 3 suites and then they have done heating and ventilation, the heating and ventilation work must be completed as per TECA ventilation checklist. So there's a ventilation checklist in the BC Building Code, and they had to make sure that all the units comply to Section 933.34 of the BC Building Code. Conclusion, it may not be clear to prospective purchasers that the work done on the dwelling units at the property has not been permitted or inspected by the town and is not in compliance with the BC Building Code and the building regulation bylaw, or that the building is in unsafe condition. Registering a Section 57 notice on the title to the property should alert the public and prospective purchasers of the unpermitted work and safety issues. Notified person would be directed to the town hall where they could obtain copies of the building file for the property and this report. The town is not aware of the owner making any attempts to correct the unsafe condition identified by the building inspector. Fire and safety of the public is at most concern to the town. And that is the purpose of the building bylaw and BC Building Code is fire, health, and public safety. In case there's a, God forbid, if there's a fire, they will not get any insurance because there's no permit taken out. Furthermore, the town may be liable in the event of unfortunate situations, such as fire were to occur, and the town did not act to rectify contravention or make sure the future tenant and owners are aware of this. So the options for the councils are, number one, council may choose to support the recommendation. Number two, council may choose not to support the recommendation. Number three, council may choose to refer back to staff for additional information. Staff recommendation, that council direct this corporate officer to file a notice pursuant to Section 57 of the Community Charter, be filed against the title of the land described as PID 006-909-248, Lot 5, Block 7, District Lot 2450, SDYD, Townside of Oliver, that certain works have been undertaken on the lands contrary to the Town of Oliver Building Regulation Bylaw 1387, and that information about the works may be inspected at the Town of Oliver Municipal Hall. Any questions for your worship or council?
Are there any questions for the building inspector? Councillor Ventimiglia.
Yeah, thank you for that presentation. We received some correspondence today and a lot of sort of signed articles, basically people saying that the apartments that are up there have existed for years. And so my question is that I think that I understood from the report as well as the presentation that that's not something that is necessarily even being called into question. It's more just that works have been recently undertaken on those apartments that are in contravention of the building code. Did I understand correctly?
Yes, you did. Yeah, thank you.
Okay, thank you.
You're welcome.
Councillor Grace.
Thank you, Your Worship. So somewhat along the same line. So, and we did receive a ton of information today, so I want to try to keep it, focused on what we're actually looking at here. So I think what we're looking at, to me anyways, is some pretty serious safety concerns. So I guess my question is, if we do agree to the Section 57, is anything aside from fixing those safety concerns going to be required, such as the options that were in the November 7th letter, either decommissioning the suites or having to take out a building permit to create 2 new dwellings? Are any of those things going to be required, or are we only addressing the safety concerns? Thank you.
Yeah, thank you. No, right now, section 57 covenant is only to notify future buyers, stating that there was some work done without building permit. And basically, when they, if the property goes for sale, then they will have this information through land title when they do title search. And that time, when they come to our town of Oliver, we will give them all the information, say all of this work was done without permit.
May I follow up, Your Worship?
Yes.
Thank you. Okay, so if the section 57 is going to say that the work was done without a permit, I guess I go back to if it was already 3 units, would a permit have been required to do upgrades rather than, I don't know if we're talking about a building permit was required to create 3 separate dwelling units, or if a permit was required to do the upgrades, and that's what we're addressing in the section 57.
A building permit was required to create 3 units. And this is a part 3 building. So they had to make sure that, again, all the floor assembly and all the rating, everything meets. They had to address both occupancy at the same time, upstairs and downstairs. So based on our information and our records, and then by pulling out all these electrical permit records from technical safety, some of the permits were taken out May 24, 2020 for electrical work. And the work was done like adding panels, electrical plugs for the stoves. So we know, but based on that, the suite might be created afterwards.
So we do have letters from residents of the town stating that it's been 3 separate units for decades. So that's where I'm a little unclear then of what's being required.
So our files, like our record in archives, we have no records of the suites were there. Very last permit, like I pull out all the permits that we have on the record. It was for $35,000 in April 7, 1987 for a relocation of a washroom in the existing restaurant. So I got all the permits from our records, and there's no permit of suites being created.
Okay, I'll leave it at that for a moment. Thank you, Your Worship.
Councillor Mattis.
Thank you, Your Worship. I think the existence of the 3 suites over the years is a bit of a red herring. I do have some familiarity with that building over the years, but we won't go into that at this point. When I read through section 57, the council has all the standing they require on the basis of the report that we have in order to put this against the title of the building, which I would be in support of doing. My question through to staff, and I'm not sure who on staff would be able to answer, is do we have any further recourse beyond this to enforce our building regulations and the BC Building Code? What would our next steps be for enforcement here? Because there are risks and there are issues involved.
CAO.
Thank you, Your Worship. The next step that if council would want to do would be to take legal action and have an injunction put against the property. But currently right now, staff are indicating it's a health and safety issue and that a notice on title will provide the notice to individuals in the future that there are outstanding issues with respect to the building bylaw and the BC Building Code.
I respect that, CAO, but that only solves that for the next person that purchases the property. It doesn't do anything to improve or change the safety of the people that are occupying what I believe to be illegal suites up in that location. If I'm wrong, I believe you're only allowed to have 1 suite in any of those zones. We're not allowed to have 3 suites in that particular zoning. So my question again would be, will we be approaching our legal team to determine what action we can take to decommission those illegal suites in that location?
CEO.
Sorry, I meant to lower my hand. Thank you, Your Worship. What steps you'd have to direct us to go that direction, because it is your ability through council, through resolution, to direct what you would like done with regards to those buildings.
Okay,
And
that I understand that. So that would be the next step for council. Appreciate that.
okay,
I also, through to the mayor, I also see that we are supposed to allow the owner or the owner's agent to make presentation to council before we make any determination on this as well, according to section 57 there. I'm not sure what the process is, but thought I would ask.
Yeah, I definitely will be calling on Mr. Rodriguez and his lawyer, but I thought I would take some questions for our building official just after he finished his report. And I have one more for Councillor Schwarzenberger, and then I will go to Mr. Rodriguez and his lawyer.
Thank you, Your Worship. Obviously, the work that's been done on this place has not met code, and that work was done a long time ago to create 3 suites that no one knew of. And I think, the least we can do in this case is do a section 57 so that other purchasers may be made aware of the unsafe condition of the upper floor with the 3 suites there. If there was a section 57 there before, if the town had become aware of this before and put a section 57 on it, Mr. Rodriguez may not have purchased the property, or may have purchased the property for a much less price, because he would have known that remediation had to be done upstairs as well as to the restaurant. So I think this is the least we can do, and I agree with Councillor Mattis that we may have to go further. Some of those there are bedrooms up there with no windows, no secondary escape in the event of fire, and that's just not acceptable. So thank you, Your Worship.
CEO.
thank you, Your Worship. I would just like to advise council that this is a hearing. And so you have to make sure that you hear from both sides with regards to this before you start discussing the direction you would like to go with regards to how you're going to handle this. So it's like a quasi judicial hearing is what is happening here.
Thank you, CEO. And on that, I will go to either Mr. Rodriguez or the lawyer, Mr. Alan Sipal. Which one would like to talk?
Your Worship, my name's Alan Zeppel. I'm counsel for Casaluna. Is my video not working?
No, it's not.
Oh, really? That's interesting.
Just have your name up there.
Okay, well, I'm not. Because I have a camera. I tested the system yesterday, but I'm not, this platform, the format in which it appears on my screen is a bit different from what I'm used to.
Mr. Zeppel?
Yes.
You've been promoted to a panelist, so you can unlock your video now.
How do I do that?
You should have a
Top of your
the bottom
screen.
of your screen, a little
Top
video.
of my screen?
Yeah, on your screen.
Um,
By your mute button, it should say video.
oh, there I
There you
am.
go.
Okay, I'm live. First of all, I want to just emphasize the comments that Kathy Cowan just made. One of the documents that I sent you today was a copy of a decision of the Court of Appeal, which dealt with a comparable section under the Municipal Act. And in that case, the court set aside a notice issued under that section, now section 57. But in doing so, it said this. It said, in light of these provisions, I am satisfied the legislature intended the municipal council to exercise its powers judicially, that is, to decide impartially as between the landowner and the building inspector, whether the conditions set out by the building inspector existed, and if so, whether they warranted the sanction contemplated by the section. I'm a little bit concerned that some of the members of council seem to have prejudged this before I've even spoken. But having said that, I will make my submission and we'll let the pieces fall where they may. At the end of the day, I will submit to you that the building inspector has failed to prove the conditions required for the remedy that he seeks, but that in any event, the sanction that he seeks is not warranted. You have a discretion as to whether or not to grant the remedy that he seeks, and I submit that you should decline to exercise that discretion. Before I get to the nuts and bolts of my submission, I want to talk about how we got here. It is important for you all to understand that the principals of my client came to Oliver with the best of intentions. They made a point of consulting with the town so as to be sure that what they were planning met the town's requirements. One of the statements that I sent you today was the statement of Reuben DeLuna, who is one of the owners of Casaluna Cuisine Corp. And if you have that statement in front of you, I'm going to refer to beginning at paragraphs 2 to 4. He says, I and my wife, Anna, are permanent residents of Canada, having emigrated from Mexico in about 2012. We had been living in Langley for a number of years and decided to move to Oliver in the fall of 2019. In connection with the move to Oliver, we were looking for a building that we could use to operate a restaurant as well as a vacation rental business. The building at 6228 Main Street was attractive to us because the downstairs space had previously been used as a restaurant and most of the improvements were in place. The second floor also had 3 self-contained apartments with kitchen and bathroom facilities which were occupied by tenants and which were in poor condition. Before completing the purchase of the building, I approached the town of Oliver to inquire about whether or not the upstairs apartments could be used as a vacation rental business. I cannot now recall who I spoke to, but I was told that it could be used for that purpose. And the provision of the bylaw that prohibits Airbnbs at that location wasn't passed until after my client's purchase. My client's purchase at the end of October. The prohibition against vacation rentals wasn't passed until November. So they were told at the time that yes, they could use the building for an Airbnb. He also had discussions with Wade Bliss, the former building inspector, but both before and after the purchase of the building about the renovations that he was proposing. He was anxious to ensure that he fully complied with the town of Oliver rules and building bylaws. And as a result of his discussions with Mr. Bliss, it was determined there was work which was required in the restaurant. They had to do something about a handicap washroom, and a permit was issued for that. It was done by the previous owners as a condition of closing. They consulted with an electrician about upgrading the electrical work to make sure that the electrical work was safe. And that work was eventually done by electricians under permit. The electrical is not within the jurisdiction of the town of Oliver Building Department. That's Technical Services BC, I think they're called, I'm not sure. Anyway, there were permits issued for the electrical work that was done to upgrade the electrical in the upstairs apartments. And he also had discussions with Mr. Bliss about proposed cosmetic upgrades to the apartments, including flooring, windows, drywall repairs, painting, new cabinetry, new sinks, new toilets, and new stoves. Mr. Bliss attended at the site and confirmed that the work did not require a permit. He did not raise any concerns about the existence of the apartments on the second floor. Now, I think it was Mr. Schwarzenberger who said that nobody knew anything about these apartments. Plainly, the town did know. And you know, Mr. Bliss was your spokesman of the town. He spoke for the town. I'd also refer you to tab 2, or not tab 2, but one of the statements I sent was from a Mason Dieter Schmidt. He was, may not now be, but he was at the time an employee of Casa Luna. He was the back house manager for the restaurant. And he's very specific. On October 23rd, 2019, Wade Bliss came to Casa Luna to finalize an inspection of the building in order to obtain a business license by the town of Oliver so that we could open on our goal date of November 9th. This was before closing. You know, my clients approached the town because they wanted to be sure they were on site, and they did it before closing. When he first inspected the building, he mentioned a handicap washroom would need to be built for the restaurant. The back doors would need to be made fire safe, and a hole in the part of the kitchen ceiling that had to be closed for the safety of the apartments upstairs. So he specifically referenced the apartments upstairs and addressed fire separation issues. He was asked if any building permits were needed for both the first and second floor of the building. Due to the nature of the renovations, the only building permit he said we needed was for the handicap washroom. No other building permits were needed for the upstairs apartments because there were no major changes to be done. And again, if you look at tab 3, this is Reuben DeLuna's son. He gave a statement, sorry, these are my tabs. I didn't give it to you in a binder, sorry. It's one of the disadvantages of doing these things remotely is I can't hand you exactly what it is that I'm looking at. But he gave a statement in which he said he was present with his father on one occasion when the former building inspector Wade Bliss attended at the second floor of 6228 Main Street. He says, when my parents purchased the building, there were 3 self-contained apartment units on the second floor, and they were in the process of being renovated. I overheard Mr. Bliss say to my father that the work that was being performed did not require a permit. I did not hear him express any concerns about the fact that there were 3 apartments on the second floor. And then finally, I provided a statement from Keith McIver, who was the contractor who did the renovations. And he described the work that he did. He said that there were 3 self-contained apartments at that location, each with their own kitchen and bathroom facilities. The apartments were fairly run down and, based upon my observation, were many years old. The work that I performed, including replacing the flooring, repairing drywall, minor repairs to windows and doors, installing new cabinets, toilets, sinks, and taps. None of this work requires a permit under the building bylaw for the town of Oliver. And I don't know if you have access to the bylaws immediately in front of you, but if you look at paragraph 13 of the bylaw that Mr. Patel is relying on, it specifically exempts plumbing work which consists only of repair or replacement of faucets, toilets, sinks, basins, water filters, water softeners, or water heaters, provided the work does not involve any alteration or replacement of pipes or fittings within any wall, ceiling, or floor structures, or in any crawl space or attic. It also exempts floor and interior wall finish and repair, decorative millwork and cabinetry changes in residential buildings, repainting, door repair, or window repair or replacement, provided the work does not include any changes to sheathing, floor or roof structures, walls or wall openings for doors, windows, or passages. Now, Mr. Patel's attached all these photographs that he took during his second inspection on December 23rd, which he says shows new plumbing. But the new plumbing he shows is exactly what's described as being permit exempt in paragraph 13 of your bylaw. Anything that's in the walls, he obviously did not see. And the evidence is that nothing was touched in the walls. It was all exempted work, and your building inspector approved it as exempted work. You know, There's been some sort of ambiguity, I guess, in the question of whether or not the building department is now complaining about the existence of the three apartments or just the work that was recently done. Councillor Vetemilla asked the question as to whether or not there were challenges to the apartments. And I understood the response to be that the town building department was only concerned with works recently done in contravention of the code. But that's clearly not the case, right? The concern really is with work that was done long before the current building bylaw was enacted. Because this building bylaw has only been in existence since 2006. It is clear, I submit, that these apartments have been there for many years, and it's likely that the town knew about it. Certainly before Wade Bliss went there in the fall of 2019, I submit it's likely that the town knew about it. If you look at, I provided a statement from Debbie Perch, who was the realtor who was involved in this purchase. And she says that prior to the purchase, there were 3 self-contained apartments on the 2nd floor of the building, all of which were occupied, and that they had the appearance of having been many years old. One of them, she said, had been continuously occupied for 25 years. There was no evidence when she inspected the property of any recent renovations to the building. Brian Amos, who I'm sure some of you know, gave a statement in which he said that he was familiar in the building because a friend of his lived upstairs in the late 1960s and he visited him frequently. He said there were multiple dwelling units on the 2nd floor in the 1960s. There was his friend lived at the one at the front, there was one at the back, and although he was never in it, there was a 3rd door which he believes led to a 3rd apartment. And finally, there's the statement of Judy Schweitzer. And, you know, this is a bit challenging, but she says she knows very well a person who was the property manager for that building in the late 1990s through to the early 2000s. That this former property manager informs her that there were 3 apartments on the 2nd floor at that time, which were self-contained, and they were not new then in the 1990s. This person has refused to come forward and provide a name. She says she, quote, has to live with these people, quotation mark. There's some concern about retribution, I guess, from the town. That's something that Mr. Schmidt talked about as well. He tried to get a hold of contractors who had worked in the building, but no one wants to talk. But she's confident that that information is accurate, that they've been there since the 1990s. I can see that there's a big gap there between 1960s and the 1990s. And, you know, we don't know what happened in that 25 or 30 years, whether the apartments as they exist now are the same as the apartments as they existed in the 1960s. But it's clear that there have been multiple dwellings there for a very long time. And it's unlikely that the town did not know. If you look at again, at Reuben DeLuna's statement. At paragraph 20. You know, we asked the town to provide us with evidence to support their contention that there were recent renovations done to this building. And the town's position was, we don't have to give them to you. You have to go under the Freedom of Information Act. And so Mr. DeLuna did make a Freedom of Information Act request, and we got some documents as a result. It says the documents disclosed by my Freedom of Information Act request do not include any documents relating to the building prior to 1978. There's no building permit for the building itself. No building permits relating to previous restaurant installations dating back to at least the 1940s. and no building permit for the front apartment that Mr. Uhl and Mr. Patel both acknowledge is a legal dwelling unit. You know, there are certain, you do see some cases where courts have been prepared to infer that work was done without a permit because the record is good. And so they can look at a point in time and say, well, there was a permit issued to construct a single bathroom in that basement in 1954, and now there are two. So we will infer that the second one was built without a permit. But here there's just nothing prior to 1978. He said in fact, this is true. There are a number of building permit applications relating to various improvements to the ground floor from 1978 through to October 2020. These are all different restaurant improvements. But one of those improvements includes the installation of 2 layers of fire-rated drywall on the ceiling of the restaurant in 2016. Somebody was concerned in 2016 about fire separation between the restaurant and the upstairs. It's likely that the town knew no later than 2016 that there were dwelling units up there that needed protection. You know, unfortunately, the town lacks much of an institutional memory in relation to this building. You know, the previous building inspector was there for, I think, over 25 years. Mr. Uhl and Mr. Patel have both been there less than 2 years, so they're coming in cold. You know, the fact that they don't have any institutional memory themselves, and the fact that the town's record keeping seems to be a bit deficient, creates challenges. But the challenge is for the town. The town must prove what it alleges. It's not up to us to disprove it. And just before I move on, I want to address, I haven't addressed this yet, but one of the things that you need to understand is that if you look again at Mr. DeLuna's statement, he says the purchase of the building completed on October 31st, 2019. You know, if Mr. Bliss had said these suites aren't authorized, they're unsafe, and if the town had said, no, you can't conduct a vacation rental out of that premise, my clients may well have walked away. This building, they might have concluded that this building didn't suit their purposes, but in reliance on the advice of the town, they completed. Following completion of the purchase and in reliance on the advice from the former building inspector, Mr. Bliss, I arranged for the required electrical work to be done by Superior Trade Services. That work was all done under permit. Proper permits were obtained for the work. In addition, I arranged for cosmetic upgrades to be performed. I've gone through the invoices which I received for the work performed. The invoices that I have been able to locate total approximately $123,500. That's money that he spent in reliance on representations from the town. And that should give you pause. What I've said so far sort of sets the scene for what happens next. Although it is not disclosed in his report to you, Mr. Patel and Mr. Uhl conducted an initial inspection on November 10th, 2020. And that's described by Mr. DeLuna at paragraphs 7 to 9 of his statement. He says that after completion of the renovation work, my wife and I began to operate our Airbnb business. I was not aware that when we started to operate, that the town had amended its zoning bylaw on November 25th, 2019 to prohibit the operation of a vacation rental business at our location. I later received communication from the town to indicate that the operation of a vacation business was prohibited. And as a result of that communication, my wife and I stopped operating that business. The town did, in fact, issue 2 bylaw offense notices in relation to that contravention, but they've since been canceled. On November 10th, Randy Uhl and Farouk Patel came in and conducted an inspection of the building. I believe this inspection took place as a result of complaints received about the vacation rental business. In his report to council dated April 26, 2021, Mr. Patel does not disclose this. At the initial inspection, I found Mr. Patel to be cordial and polite. I recall him mentioning the fire extinguishers were incorrectly placed, and he may have said something about possible fire separation issues. But in general, he did not seem to have any serious concerns. The main focus of that discussion that day involved Mr. Houle, who insisted that new dwelling units have been added without a valid permit, and said that in order to obtain a permit, he would have to pay a penalty of $32,000 because he could not provide off-street parking. Mr. DeLuna challenged Mr. Houle's contention that the dwelling units had been added without a permit. The next thing that happens is that I'm not quite sure why Mr. Houle was involved in this inspection at all. Your building bylaw does authorize building inspectors to enter premises, but it doesn't authorize people who aren't designated as building inspectors to do so. It's not in his job description. As far as I know, he's not been designated as a building inspector or a person authorized to enter, but he was there in any event. And following that initial inspection, he wrote a letter, which is at pages 6 and 7 of Mr. DeLuna's statement. And the entire focus of that letter is the existence of these 2 additional dwelling units. He says the inspection revealed that extensive renovations have recently been completed on the 2nd floor of the building. This work was not authorized by a building permit and therefore violates section 12 of the town's building regulation bylaw. The addition of new dwelling units at this address, okay, also creates a further contravention of the parking regulations set out in Part 8 of the town's zoning bylaw. And this is a relatively new bylaw provision which requires off-street parking or a penalty in lieu of off-street parking for new development. Question whether or not units that have been there since possibly the 1960s are new development, but in any event, Mr. Houle was very concerned about his parking penalties. And he gave him 2 options. One was to apply for a building permit to decommission the 2 unauthorized suites. Another was to apply for a building permit for the alteration of the original suite, because he doesn't dispute that the front suite is legal, although there's no building permit for it. And creation of 2 new dwelling units. He says, and this is important, given that the work was completed without a permit, it is difficult to determine the level of fire separation constructed between uses. Therefore, an alternative solution from a code consultant will be required to accompany the building permit application. So the point of that is they conducted an inspection on November 10th, and they found no defects that they could identify. The entire focus was off-street parking and these so-called unauthorized suites. He did say, there's a possibility of a fire separation issue, but it's not something that they'd identified or established. And when I come to deal with the technical requirements for issuing the Section 57 notice, one of the things I will say to you is that the absence of evidence is not proof. And what Mr. Patel has mostly offered you is an absence of evidence. Now, you may well imagine that my client was dismayed at receiving this letter. Firstly, Mr. Houle says things that are not true. He says he refers to the recent creation of new dwelling units, and we know that's not true. He refers to recent work for which a permit was required, and I submit to you on the evidence that that's not true either. Secondly, he asserts that 2 of the 3 suites are unauthorized. And he says that after my client sought and obtained advice from the town that his rentals did not require a permit, and spent $123,000, give or take, in reliance on that advice. Who would spend $123,000 to renovate unauthorized suites? And thirdly, Mr. Houle is characterizing his new development for the purpose of the parking regulations, suites that we now know have existed for at least 20 plus years and likely much longer than that. I submit that anyone in the position of Mr. DeLuna and his wife would have been taken aback by that letter. And so and fair-minded people would understand my client's distress at this turn of events, that the town has told them at point A that, no, you're okay, go ahead and do the improvements. And at point B, the town comes along and says, well, you know, the joke's on you, those suites are illegal. It strikes me, and I haven't dwelled on this, but it strikes me that the town might have some legal exposure for the advice that the town gave. Anyway, my client retained me. There was an exchange of correspondence. You know, Mr. Patel says in his report at page 3, paragraph 3, he says the town has repeatedly notified the current property owner that a building permit application must be legal unpermitted suites and correct the existing contraventions of the building bylaw and building code, but the property owner has refused to comply. An examination of the record, I would suggest, shows that that is not a fair characterization of what transpired. If you look again, attached to the statement of Mr. DeLuna at pages 8 and 9, I wrote a letter to Mr. Rule in response to his letter in which I disputed his claims that there had been extensive renovations had recently been completed or that new dwelling units had been added. But I went on to say in the last paragraph, if you have any evidence to show that my client has performed work apart from the electrical work for which a building permit was required, please provide that evidence. In the absence of such evidence, my client has no intention of applying for a building permit and maintains that no bylaw violation has occurred. This isn't an outright refusal. This is, you know, this is contrary to what we've been told. If you have other evidence, show us. It's a perfectly reasonable position to take. The next step in the process is a letter from the solicitor for the town, Young Anderson, in which he says, that's at pages 10 and 11 of Mr. DeLuna's statement. He says, you've advised that your client alleges that the unpermitted renovations which have created 2 additional unauthorized dwelling units were completed prior to your client's purchase of the property. The town's building regulation bylaw 1140 make any owner of a property responsible to remedy outstanding bylaw infractions as such infractions are identified, and regardless of whether or not the work in question was done by that owner or a previous owner. Therefore, your client must remedy the identified infractions regardless of whether or not they own the property at the time the unpermitted renovations occurred. And so I responded to that letter again at pages 12 and 13. And I say, you know, your letter necessarily presupposes that the apartments were constructed as a renovation to an existing building and that the renovations were not permitted by the bylaws at the time they were made. You know, and I concede that if, you know, when these apartments were built, if they were built in 1965 or if they were built in 1985 or whenever they were built, if they were built without a required permit at the time, then my client could still be responsible for that defect. But that's not what the town is saying. The town is saying you didn't get a permit required under the current building bylaw that's only existed since 2006. And I go on to say, do you have any evidence to support these allegations? If so, what evidence? When do you say the apartments were constructed? What do you say the relevant bylaws were at the time, and what were the particular terms that were contravened? And that's a reasonable dialogue when you're looking at a building that's this old with apartments that are this old, apparently this old. Show us what the bylaw provisions were at the time and show us where in your records that the work was done without a permit. And the town has 2 problems here. One is they haven't produced old bylaws, and 2, their records in relation to this building, it appears, are woefully inadequate.
Mr. Zeppel, is
Yes.
it possible to ask a few questions here?
Absolutely.
Mr. Zeppel, if the town went back to its bylaws, if I heard you correctly, and determined that whenever the apartments were built, that they were built in contravention of the bylaw, then your client would be responsible for remedying that. I did hear that correctly?
Well, I guess, I think that's a possible result, I've
Okay,
been
so
focused.
I did hear it correctly then. Okay, so I did
Sorry?
hear that correctly. So
Well,
then if there was never a building permit taken out, then there would be no record in the file regarding the construction because a permit was never taken out. So there is no records.
Well,
So as poorly kept as the records may be, they don't exist because the permits weren't taken out. But all of that aside, I want to go right back to the beginning if I can. You talked about plumbing that was allowable and you talked about window repair and replacement.
Yes.
And my question was regarding the window repair and replacement. You said something about if it didn't require any change to the wall or anything like that.
I think the bylaw says, I can read it to you exactly.
I don't have all this documentation in front of me because I arrived just before our previous meetings and had no opportunity to review it because it arrived so late today. So I'd appreciate if you could read that part to me about when you replace windows.
It says window repair or replacement, provided that the work does not involve any changes to the sheathing. I take it that means you can swap out windows of the same size, but I'm not a building guy.
So what you're suggesting is if the windows were of a different size, then that would be a problem. It would require a permit.
Yes. I believe
Okay.
that to be the case.
Okay. I only ask these questions because I own the building next door and watched the windows be replaced and the size was changed. I just wanted to throw that at you. Maybe your client didn't let you know that. You wouldn't have had access to that side of the building because it's on the roof of the building next door, but it's plainly visible that the size was changed. So I just wanted to point that out to you before you go too far along here. Just a couple little things, but I do appreciate all the points that you raised to this point. Thank you.
Well, if the point is that he needs to apply for a permit to change the size of the windows, that's quite different from applying for a permit to allow 2 new apartments, right?
I totally support what you're saying there. And if the apartments were constructed against the bylaws at the time, that's a whole different issue. And as no one knows when, we would have to look at the bylaws in the past to determine whether they fell under the bylaws or didn't fall under the bylaws and take appropriate remedies. It's not that hard to track down people that lived there in the past.
Well, there's 2 parts to that. You'd have to go back to the original bylaws and see what
Exactly.
the bylaws said at the time. But then you'd have to decide whether or not the state of the records allowed the inference to be drawn that no permit was taken out, because it looks as though your record keeping is really poor.
Well, there would be no record if no permit was taken out.
That's true.
So this is a situation where the lack of evidence demonstrates what occurred. A permit wasn't taken, so therefore it doesn't exist. The records are poor because no record was ever made because it didn't exist.
Or the town of Oliver's record keeping and collecting is not very good.
Are you suggesting we've been deceitful in this matter?
That wasn't a suggestion that you're being deceitful. What I'm suggesting is that I was surprised at how little the Freedom of Information Act request produced.
Well, that's having worked with Freedom of Information myself before. Unfortunately, they have to be quite specific what you're asking for. It's a very frustrating process. I totally understand.
I asked for all records.
I'm going to just jump in here a bit. Are you just about finished, Mr. Zeppel, with what you have to offer, council, before we have some debate amongst ourselves?
I'm not really. I have more to say. I haven't really got to the substance of whether or not there's any proof that the building's unsafe. My position is that there really isn't. That what the evidence consists of is a series of a statement saying, I can't tell because there were no inspections done because there was no permit. Well, there are ways of addressing that issue that don't involve something as draconian as a Section 57 notice. You must affirmatively find that the building is unsafe. And all that Mr. Patel is saying to you in his report is Well, we don't know because no inspections were done.
I think Mr. Patel might also be relying on section I of the section 57. Something was done with respect to a building or other structure, or the construction of a building or other structure that required a permit or inspection under a bylaw, regulation, or enactment referred to in paragraph A1, and the permit was not obtained or the inspection was not satisfactorily completed. That in itself is sufficient for section 57.
Yeah, but his complaint is that the apartments were built without a required permit under building bylaw 1104. That's his complaint.
So what you're suggesting is that this complaint should be put aside and then a different complaint could be made that would stand the test.
Well, there may well be a different complaint that can be made, but I'm saying that this one hasn't been made out. You know, you need the evidence of work being done without a permit. And I can go through that. I intend to go through that, but it's shockingly skinny. Given the remedy that is now being sought.
Can you say something?
Sure.
Yeah, it was. I just want to add that's it's not only the building bylaw they have to comply, BC Building Code and the zoning bylaw. The section 1212 of the BC Building Code, and it's always been there. And you know, BC Building Code change every 5 years. So it says responsibility of the owners. Sentence 1 says, unless otherwise specified in this code, the owner of a building shall be the person responsible for carrying out the provision of this code in relation to that building. Sentence number 2, it says the owner of a building is in no way relieved of full responsibility for complying with this code, BC Building Code, by the authority having jurisdiction, A, granting a building permit, B, approving the drawings or specification, or C, carrying out inspections. It's still owner responsibility to make sure it comply with all the code requirements.
Well, I understand that as well, although, and again, I'm not a building code person. My understanding is that there are rules that apply to the way the current building code is applied to old buildings. You know, my understanding, for example, is the current building code requires 2x8 construction for insulation purposes.
It does not require 2x8 construction.
What does it require? 2x6?
You can do 2x4, 2x6. It depends on your construction method.
On exterior walls?
Yes, we have a house they do 2x4 because they do spray foam insulation. So I don't want to go there, but I want to add a couple more things. We had a building record, building permit. It was applied 1978. So that was the work for rear portion of existing building. And then we have the record because they applied for the permit, 1978. Then we had the permit, 1987. We had a building permit for $35,000. That was relocation of staff washroom in the existing restaurant. So again, whenever they apply for the permit, we have the records. There was a pizza restaurant or something before. We had the records of the permits that was applied.
And where's the building permit for the building itself?
Well, I'm asking you, what is the building permit for all the suites, right? The other permit we have for downstairs is they did the Nfpa 96 kitchen exhaust system. So we have the record for all the drawings and all the permits, including the number of seats downstairs and again, kitchen exhaust system. It was done by mechanical engineer. So we have all the records of the permit they applied for.
Yeah, but there's no building permit for the building itself. And
They
there's
didn't
no,
require them 75 years ago.
there's no building permit for the one bedroom apartment that is, everybody acknowledges is legal.
The apartment was there when the original apartment was there when the building was built 75 or 80 years ago. No permits were required at that time.
Well, apparently there were 3 apartments in the late 1960s.
No, there were not. My brother lived up there. I'll be happy to bring him in as an expert witness if you wish.
Point of order.
Yeah.
Yes, Councillor Grace.
Can I ask that Mr. Zeppel be allowed to finish his argument so that council can debate the matter on the table? Thank you.
Mr. Zeppel.
Yeah. Anyway, the point of going through this correspondence is to show, not only did my client rely on the advice that the town gave him, but we actually attempted to engage in a constructive dialogue with the town, and we're basically stonewalled. No, we don't have to give you any information, and we won't. Well, this exchange of correspondence was going on. There was some communication between my client and Mr. Patel. At paragraphs 13 and 14, he says, after he received Mr. Hoole's original letter about the parking fees, Mr. Patel came to see him at the restaurant. He said he felt badly about the letter and that he would help if he could. After he retained me to represent him, he received a notice that Mr. Hoole and Mr. Patel intended to conduct another inspection of the premises on December 23rd. Because Mr. Patel had previously offered to help, my client phoned Mr. Patel. Mr. Patel told him that Mr. Hoole had spent the morning of that day calling contractors around Oliver to see if he could find out who had done the work on the apartments. He said that he'd been instructed by Mr. Hoole to go in and find something no matter what. He also said that the conversation was private, and if he made my client make it public, that he would deny it. And I put that in there, and I know it's difficult evidence for you to have to deal with, but part of the concern here is that there was an inspection conducted on November 10th, which resulted in no findings of both code violations, raised the possibility that there's a firewall separation. And then there's a second inspection conducted on December 23rd that appears to have been conducted with an agenda. At the end of all of that, of course, he's faced with this draconian application. Between the time of the first letter from Mr. Hoole raising the parking fees and the time of the delivery of this Section 57 report, there was no communication from Mr. Patel or the Building Services Department identifying code violations that needed to be corrected. So when Mr. Patel says in his report, the town has repeatedly notified the current property owner that a building permit application must be made to legalize the unpermitted suites and correct the existing contraventions of the building bylaw and the building code. I submit that that's just not true. There's no notice to correct identified defects in the building code. And if you look at his report as a whole, there are a couple of building code violations that he's identified that can be easily corrected, but the conclusion as to safety, and I admit that safety is a legitimate consideration for the town, the conclusion as to safety is really based upon not much more than the fact that because no inspections were done, we can't tell. In his report at page 2, Mr. Patel sets out Section 57 of the Community Charter. And as he's correctly noted, a Section 57 notice is available either under Section 1A, subsection 1A or 1B. 1A is available where the building inspector observes a condition that the inspector considers results from the contravention of or is in contravention of a municipal bylaw, a provincial building regulation, or any other enactment that relates to the construction or safety of the buildings or other structures, and that as a result of the condition, a building or other structure is unsafe. He has to identify the condition that violates the building code, and then he has to form the opinion based upon that the building is unsafe. The other option is in B. It says if something was done with respect to a building or other structure or the construction of a building or other structure that required a permit or an inspection under a bylaw, regulation, or enactment, and the permit was not obtained or the inspection not satisfactorily completed. I'm going to deal with these in reverse order. I'm going to address 1B first.
Mr. Zeppel,
Yes.
I'm going to give you 5 more minutes. And then I'm going to cut you off and we're going to have our debate. I think we've had enough information. This is going around in circles with all due respect. So please take your 5 minutes and complete your argument and let us know what else you have to say that's based in fact, please.
It's based in fact. Well, with respect to 1B, the bylaw that Mr. Patel relies on was not enacted until 2006. It's apparent from his report that the work he's relying on was completed prior to the enactment of this bylaw. That is the suites. You know, on the statements that I've given you, I submit that's the only proper conclusion. But even if you look at his report itself, he asks you to draw the inference that there was work that was completed without a permit based upon, you know, the new appearance of the suites. Well, of course they look new, right? They were renovated, they were upgraded. He asks you to infer that the suites were built without a permit because the assessment notice shows no record of more than one dwelling unit. But if you actually look at the assessment information, which I have attached at pages 19 and 20 of my client's report statement, it just talks about residential premises. It doesn't say one, it doesn't say more than one, it doesn't say anything. So there's no inference to be drawn from the BC assessment information. And as I've said, there's no inference to be drawn from the records that the town has produced about building permits. As to 1A on the issue of safety, you know, in Mr. Uhl's first letter back in November, he didn't identify any code violations. He just said more of an investigation was needed on fire separation. If you look at the building inspection report attached to Mr. Patel's report, you get more of the same. He just says it more often. You know, one of the other things that Mr. Patel says in his report is that the technical safety BC permits show that there was a bunch of plumbing work done and other work that needed a permit. I've produced and attached to Mr. DeLuna's statement copies of the inspection reports that have been produced by the town, and there's nothing in there at all about plumbing work or other work for which a permit's required. It's all about electrical work. And as I say, electrical work is not within the jurisdiction of the building inspector. Anyway, coming back to the safety issue, if you go to the inspection report, if you look at paragraph 1 on page 1, he says, since the town does not have record of any issued building permits for the unauthorized suites, and since the building is in a finished state, I could not verify code compliance. Well, can't verify non-compliance either. And what he has to do is prove non-compliance. If you look at paragraph 2, it's much the same. A complete code analysis is required by a code consultant to properly classify the building. Since no inspections were ever inspected from or carried out by the town of Oliver as required by the building bylaw. Well, that's not confirming code violations. That's just saying we need to investigate more. And I fully accept that. You know, if there are legitimate safety issues here, they need to be addressed, but they need to be addressed in a reasonable and responsible way, given the representations that were made to my clients and the ways in which they've acted to their detriment on the town's advice.
Mr. Zeppel, thank
Yes.
you. That's 5 minutes. We will debate it as a council now. Thank you for your input this evening. Councilor Grice.
Thank you, Your Worship, and thank you to Mr. Zeppel. That was a very thorough recap of the information that you sent to us today, as well as what we've received previously from our own staff. So for me, I'm willing to put aside all of the information regarding building permits, whether or not they were issued, whether or not those suites are legal or not, how long they've been there, and just look at 57(1)A as a standalone reason to allow for a section 57. So, and I'll use your own words and ask through to the building inspector if you can identify the condition that violates the building code.
Right, so let me go back to my report. The most important thing, again, if you this floor, the second floor, they have to comply with part 3 of the BC building code. Part 3 is when they have more than one suite. So it's a group C occupancy. So based on that, like I had they had to make all the egress requirements. So the front stair from the main street, they're considering exit. Every floor area, you need minimum 2 exits. So if there's a fire on one side, the occupant, they have to get out through another exit. In this one, for example, the most important one, that it's this exiting does not work. If there's a fire at night, is one of the front unit or middle or the last unit, the occupant cannot get out because they're locking the doors. The walls in between these suites, they are not, they don't have proper fire separation, minimum 1 hour fire separation. The stairs, the rise and run does not meet to part 3 of the BC building code. The fire separation of the exits when the building is not sprinkler, they have to be minimum 9 meters apart, or half of the diagonal distance of the floor area. So if your floor area is 50 feet, half of that, 25 feet. They have to be at least half of the diagonal of that distance. The travel distance, if there's a fire on one side, cannot exceed more than 15 meters. You have to reach to the exit within 15 meters. The front stair is just a stair, it's not the exit. So the front stair, to make a proper exit, they need a 45-minute, minimum 1 hour rating, same as the floor assembly. So they would have to make the rated exit, put all the proper exit signs, and they had to meet also, put all the, calculate proper occupant load. So based on the occupant load, they had to figure out the exit requirements. Also, the windows on the outside wall, it's at the 0 property line. So all the bedrooms by the building code, you require, if there's a fire in the bedroom, you're required to have minimum 0.35 square meter of the window area, or 3.76 square feet. And minimum of that, you need at least 15-inch width. So when they open the window, you need minimum 15 inches to get out. Now, these windows, they don't comply because again, they are at the zero property line. So these windows, they are at 6 feet high from the bedroom. So none of these bedroom would meet the requirement of the egress as per the BC building code. And again, if they were to have any of those windows, they have to have fire protected windows. So with the fire, with the wire glass. Because right now these windows are unprotected. If there's a fire on the next building, the fire will come into this building right away because this glass, they are not protected glass. You need to have wire glass. In order to have a window in any exposing building face, you need minimum 4 feet, 1.2 meter. If you're 1.2 meter, then you allow 7% of the window of the exposing building face. So the biggest contribution of the bylaw, egress requirement, exiting requirements of the BC building.
Thank you, Mr. Patel. And a very, very quick follow-up then. Due to these contraventions, is the building unsafe?
Sorry, can you please repeat?
Yes, due to these contraventions, is the building unsafe?
Yeah, definitely it's unsafe. Especially again, the windows at the zero property line. Not only it's unsafe for their own building, but their neighbor's building. If they have a fire in their own building, the fire would go to these windows and start the fire on the neighbor's property. So the way this window works is it's protect both sides, the neighbor's property and their own property. So definitely it's unsafe. Also, if the exits are blocked during the fire, they cannot get out because they're locking all those doors. There's no exit corridor. Whenever you have a corridor, it's usually, again, it's a rated corridor, same as the floor assembly. So if they have to escape, the corridor will stay there for 1 hour. If the stair is rated, it will stay there for 1 hour before fire department comes.
Okay, you're repeating yourself, Farouk.
Okay. Also for the fire department access, they need a window at the front so they can break in and get into and save the people if there's a fire.
Thank you. That answers my question.
Councillor Ventimiglia.
Thank you, Your Worship. I don't think I have any questions. I just have a comment or a couple of comments. I appreciate all of the information provided by the building official as well as by Mr. Zeppel. I guess what I understand is from the recommendation in front of us is that we're being asked to file a notice pursuant to section 57 of the community charter against the lands described, et cetera, regarding works undertaken.
Can I add one more thing? Sorry to interrupt you. Can I add one more thing?
Mm-hmm.
Please, it's very important. It's the gas line. So if you have seen in the photos, sorry, again, this is a big safety issue. And I talked to the gas inspector and he said, yes, I agree. And I didn't know. So every bedroom, there's an 1.5 inch gas line going through right above the bedroom. If there's a fire, an explosion, lots of people could die, right? So gas lines should be in a rated shaft. So they have to build up at least 1 hour rated shaft along the gas line. So in case there's a fire in the kitchen or bedroom, the gas line would be protected for at least 1 hour because they would be building the 1 hour rated shaft along the gas line. Also, anytime any gas line or plumbing pipe goes through required fire separation, especially like the fire separation between each suites, they need to fire stop. Otherwise, fire would go through this required fire separation and will start throughout all the units.
Thank you for that. I think,
Yeah,
your comments will kind of just go to my point that I'm going to make at the end. I guess the way that I understand section 57 as a notice in the land title office is that it will advise potential purchasers that there are 3 non-conforming and unpermitted suites. It doesn't say when they were built, nor does it require the current owners to make any attempts to remedy, if I'm understanding correctly. It was pointed out in the presentation that now that we're aware of the suites and the deficiencies, we could potentially be in a position to be liable in the case of, God forbid, fire or what was just described by the building inspector. So I believe, based on everything that I've heard this evening, as well as the report received earlier, that it's our duty to file this notice at the Land Titles Office, given the information that we have. And those are my comments.
Thank you, Councillor Ventimiglia. Councillor Schwarzenberger.
Thank you, Your Worship. I too would like to thank and commend both Mr. Patel and Mr. Zeppel for their presentations. Very informative. Safety is my main concern as well. And I'm not a lawyer, but Mr. Zeppel did intimate that there might be, that he felt that the town might be liable for the amount of work that Casaluna Corporation did on the project, the building, after they bought it. And Councillor Ventimiglia just mentioned that there might be liability for the town if there was ever some sort of terrible fire or something happened there where there was a loss of life or something like that. So I'm thinking that we should get a legal opinion from our lawyers before we proceed with this decision. I think we could put it off for another meeting or two, and then get some advice from our legal team as to our liabilities on both questions, whether we file a Section 57 or if we don't file a Section 57. And those are my thoughts. Thank you, Your Worship.
I'll weigh in. My comments would start with a thank you to our building inspector and Mr. Zeppel for providing the information that was provided. My comments are going to echo those of Councillor Ventimiglia. I think we have a duty to put up Section 57 on this title of land. I think it's the right thing to do for safety reasons. It doesn't require the building owner to do anything, so there's no cost to this other than that it puts notification on title that works that are in there are unsafe. I think it's pretty clear, and I have a reasonably good understanding of the building code myself, and it's quite obvious that there is some serious issues here around access and egress and potential hazards related to fire. So I definitely will be in support of the motion of putting a Section 57. Those would be my comments. Anyone else from council have anything to say?
Your Worship, can I add one more thing?
No, not now.
Okay, thank you.
Thank you.
Your Worship, I'll move the proposed motion that council direct the corporate officer to file a notice pursuant to Section 57 of the Community Charter against the title of lands described as PID 006909248, Lot 5, Block 7, District Lot 2450 SSDYD, town site of Oliver, that certain works have been undertaken on the lands contrary to the BC Building Code and Town of Oliver Building Regulation Bylaw 1140, and that information about the works may be inspected at the Oliver Municipal Hall.
Can I get a second to that motion?
I'll second.
Councillor Schwarzenberger, was that you?
Yes, it was.
Okay, moved and second.
Mayor Johansson?
Yes.
The applicant, Mr. Rodriguez, has raised his hand. I don't know if you can see that. I don't know if you want to allow Mr. Rodriguez to speak. That's the property owner.
I thought at this time when we have a motion that's moved and seconded on the table that we have to move forward with that without further input.
Yeah.
So we do have a motion that's moved and second. Any further discussion from council? Councillor Ventimiglia?
Yes, thank you, Your Worship. I'm just trying to flip back and forth quickly. I might be reading the wrong thing, but I believe the motion on the board is different than the one in our most recent agenda package. And I just want to make sure that we're voting on the right motion.
The motion that Councillor Grice read was what the changes is. We have the Director of Operations thought the BC Building Code and the bylaw number was not indicated properly.
Okay.
40. Thank you.
Thank you for the clarification.
Any further comments or discussion? Not hearing any, I will call the question. Is anyone opposed to the motion? Hearing none, the motion is carried. Moving on to item 2, grant and aid request, South Okanagan Healthcare Auxiliary Society. This was something on the agenda at the Committee of the Whole meeting. We had a good discussion on it. Would anyone like to make the proposed motion that council approve the South Okanagan Healthcare Auxiliary Society $8,919 grant in aid request?
So moved.
Moved.
Moved and second. Any further discussion? Not hearing any. I will ask the question. Is anyone opposed to the motion? Motion is carried. Moving to correspondence, our April 26th correspondence report. I will pass this over to the corporate officer.
Thank you, Your Worship. The correspondence report before council this evening has one council action item. That is from the Cystic Fibrosis Canada regarding an announcement that May is CF Awareness Month, and they are requesting the town of Oliver to light up with our lights, blue and or green, during the month of May. There's two options before council that you may wish to grant the request to the Cystic Fibrosis Canada to light up Town Hall during the month of May in blue and or green, or you may wish to receive and file.
Councillor Bentamina?
Yeah, I would, I read through their request. I would make the motion that we do light up the town hall blue and or green in honor of Cystic Fibrosis Month, and that we do so provided that we don't have any other colors slated for the last week of May. They don't request that we light up for the whole month, just that we choose a date that might be available. And they also mention that on May 30th, thousands of participants across Canada will unite virtually at a local community walk to make CF history event. So that timing seems appropriate. And we have the lights there ready to go, as far as I know.
EAO.
Thank you, Your Worship. Hopefully we'll have siding on the building next month. If not, we might try to light up the grassy areas.
You moved that motion, correct, Councillor Bentamina? Did you move?
Yes, yeah, I did specifically for the last week of May, but really, I mean that as long as it's sometime in May.
Okay.
I'll second.
Moved in second. Any further discussion? I'll call a question. Is anyone opposed to the motion? Motion is carried.
Thank you. And for information only, there's 4 pieces of correspondence. One from the Liquor Cannabis Regulation Branch announcing Policy Directive 21-06 that provides support and increased opportunities to generate revenue for the hospitality industries during COVID. Also an email from SILGA reminding local governments of the UBCM Community Excellence Awards. The application deadline is May 14th, 2021. And correspondence from the City of Penticton, Mayor Vasilaki. He is seeking support from UBCM to help challenge a provincial paramountcy. And lastly, correspondence from the City of Victoria, Mayor Helps, regarding support for laid off hotel and tourism industry workers. And the resolution is, which I think is up here, that the correspondence listed in K1, which I just read, and the weekly mail be received.
So moved.
Second.
Second.
Seconder, thank you. Any further discussion? Not hearing any. I will call the question. Is anyone opposed to the motion? Motion is carried. Moving to councillor reports. Councillor Grace.
She's
You-
muted.
I might have lost councillor Grace.
No, I'm here. Sorry, I was switching screens, so try that again. Sorry. So Tuesday, April 13th, I had a SILGA meeting. Thursday, April 15th, I took part in the South Okanagan Similkameen Respect Network meeting. They're working on anti-racism initiatives, incident response protocols, and an online reporting portal, as well as many other things. Friday, April 16th, I took part in a video shoot with Mayor Johansson accepting the Community Excellence Award for the Salmon Chief sculpture. So watch for that during the SILGA AGM. We had balloons and our own certificate we made for ourselves, and it was lots of fun. Monday, April 19th was the Oliver 100 by 100 project committee meeting. Lots of smaller initiatives coming up through that project, including a call for storytellers to tell their stories of living in the area. Also on the 19th, CAO recruitment meeting with the rest of council. And then later that evening was the Oliver Parks and Rec Society AGM. So congratulations to the board for sticking around for another year, followed by the Parks and Rec Society regular meeting. Wednesday, the 21st, we did a run through of the SILGA AGM so that we have a smooth AGM on Wednesday. April 22nd, I took part in the Earth Day planting of a catalpa tree with many thanks to Liz for her donation. Thursday, April 22nd, again, was the South Okanagan Similkameen Respect Network. I joined their task force, so discussing the actions that that group will be taking and today's meetings. And that's the end of my report. Thank you.
Thank you, Councillor Grace. Councillor Mattis.
Thanks, Your Worship. The CAO recruitment meetings and council meetings.
Thank you, Councillor Mattis. Councillor Schwarzenberger.
Thank you, Your Worship. April 19th, the CAO recruitment meetings and today's meetings. And also I'd like, the SILGA AGM is this Wednesday. And Town of Oliver has 4 resolutions in front of SILGA that have all been recommended apparently by the recommendation committee. So I'm hopeful that all 4 will get approved and go forward to UBCM. And that's it for me. Thank you.
Thank you, Councillor Schwarzenberger. Councillor Ventimiglia.
Thank you, Your Worship. I don't think all of us combined are going to beat Councillor Grice's really long list of meetings and events for these past 2 weeks, but I'll add my couple of notes. Wednesday, April the 14th, I attended a primary care clinic advisory meeting. Monday, April 19th, CAO recruitment meeting with the rest of council. Thursday, April the 22nd, I attended the Earth Day tree planting as well in Kiwanis Park. And I didn't know until I was there that day that the tree had been donated by a community member. So as well, I'd like to thank Liz. I think that's awesome. And then our meetings this evening.
Thank you, Councillor Ventimiglia. For myself, April 14th, Heritage Committee meeting and an Oliver Clinic Advisory Committee meeting hosted by divisions. On April 15th, RDOS and the Mayor's Vaccine Roundtable. April 16th, the SILGA Community Excellence Award video shoot with Councillor Grace. April 19th, the CAO interviews and Oliver Parks and Recreation AGM. April 22nd, Earth Day planting at Kiwanis Park. And today I found out that my name got drawn out of the hat for a Fortis BC food bank check of $1,500 to the town of Oliver. So that will be coming and we'll make that presentation in the near future. So that's really good news. What? Golf clap.
Yeah.
Birdie clap. Upcoming meetings, our next regular meeting is May 10th, 2021. And the one after that is a Tuesday, May 25th, 2021. Acting mayor schedule for April and May is Councillor Mattis. And we're going to public question period. If anybody in the public has a question on something that was on the agenda this evening, please raise your hand. I don't see that we have anybody.
No.
Okay, and then I will go to Councillor Ventimiglia. You have your hand up?
It's not a new hand, it's a leftover hand. Thank you for pointing that out.
I have 2 meetings left.
Then you can move the motion to adjourn.
Okay, I'll move the motion to adjourn,
sorry.
or I'll second it. That's okay. And I just heard the CAO say that she has 2 meetings left. Time flies when you're having fun.
Oh, 2 meetings.
That's crazy.
Okay, council, have a good evening. Thank you.